Great. So, hi everyone. Thank you so much for joining in. And to those who were with us yesterday also, welcome back to Consilience 2021. Today we have a very interesting panel on algorithms and antitrust. But before we begin, I have a few quick housekeeping announcements. So the session is planned for 75 to 90 minutes, and the last 20 minutes are reserved for the audience Q&A. So please feel free to use the question and answer portal below to ask questions. Yesterday, we had some interesting questions and conversations around them. So please do continue them. Secondly, we will be sharing the feedback form towards the end of the session. So please do fill that because it is a prerequisite for you to get the attendance certificate. So I think I have spoken too much already. I would give the floor to Mr. Padhy, who is a corporate law professor in the Christ University and has graciously agreed to be the moderator of the session. Over to you, sir. Thank you.
Thank you, Harshit. All right. Good evening, ladies and gentlemen. I'm Amit Kumar. I'm an assistant professor of law at Christ University, Bangalore. Now, I extend a warm welcome to all of you for joining us on the second day of Consilience 2021 on the theme of anti-competitive algorithms and the challenges in antitrust law. Before I introduce our distinguished group of experts to you, let me take a brief moment to discuss our agenda for today. In continuance of what we our discussion yesterday, which focused on data and abuse of dominant position, and more often about how this data will be used. Today we'll be discussing and we'll be going a bit deeper on how some more complex issues which pose a threat to the competition law, as well as the goals of competition and antitrust regimes across the globe. We're planning to discuss three major issues in today's discussion, which are algorithms and their effects on exclusionary and exploitative abuses. We'll discuss about the new age technology of blockchain and smart contracts. Just one moment. Okay. And we'll discuss about the changes which we are observing across the globe when we are dealing and when the antitrust authorities are dealing with such issues. Just to give a small example to our audience with respect to how algorithms work. Just let me pick an example of Ola and Uber. So if this is an example which Professor Rahul gave in the class where I was sitting. So when we use these applications, the pricing depends on how you have used this application in the past, or how that locality, that area, or how your peers are using that app. And as a consequence of that, we have observed that the pricing which I get for booking a ride from point A to point B is different from what my friend gets for booking the same ride for the same point A to point B. Now, on that note, I'll just briefly introduce the concept of blockchain and smart contracts, which also raises a lot of issues because of the data which these technologies store, the way they use this data, and the way they remove intermediaries from the transaction, which ultimately act as trust creators for us. Today, I'm delighted to welcome a very distinguished panel of experts to discuss these issues. We have with us Dr. K.D. Singh, Director, Antitrust Division of the Competition Commission of India, and the Central Public Information Officer of the Competition Commission of India. Thank you, sir, for joining us.
Thank you.
We also have with us Dr. Shipl, Faculty Associate at Codex Center of Stanford University, who will be joining us shortly. We also have with us Ms. Smriti, who is a fellow at CyberBRICS project. Thank you, ma'am, for joining us. We have with us my teacher and Professor Rahul Singh from National Law School, Bangalore. He needs no introduction. And if I have to give an introduction about Professor Rahul, then it will take a day or two. Thank you, sir, for joining us. And we also have with us Ms. Tatir Fatima, who is a research scholar at National Law University, Delhi. Thank you, Tatir, for joining us. With that introduction, let me start the discussion for today's evening with Dr. K.D. Singh. Dr. Singh, we have seen various cases before the antitrust authorities and the courts in India. When it comes to use of algorithms, be it the Samir Agarwal case, be it the cartelization, the airline industry case, and even today's discussion of the decision of the Karnataka High Court to not give an injunction order to Amazon and Flipkart like companies against the investigation of CCI filed by the Delhi Vepar Sun. Now, with these cases in mind, I would like to start the discussion. Can the algorithms collude in terms of competition law? If they do, how have other jurisdictions dealt with this issue from a regulator's point of view? Over to you, Dr. KDC.
Thank you very much, Amit. In fact, today's theme could not have come at a more opportune time, because only on the 3rd of this month, Competition Commission of India has issued a ruling in the airlines cartel case, and where the commission has explicitly noted the potential use of algorithms in fixing prices. In fact, this is a harbinger of the way things will evolve in the new age economy. So if you have a look at this order, which was issued on the 3rd of this month, you will see that the Director General investigation has actually looked into the softwares which were used by different airlines with a view to ascertain whether there was a common agreed programming or whether there were softwares which were used by a common developers. So I think the algorithmic collusion has arrived and it is no longer in the realm of a future. So we are very much living in this age when these tools have become very important for the businesses in this new age economy. So if I respond to the question which we have posed, let me tell you that algorithms are nothing but programs. So to that extent, as far as the legal liability is concerned, it does not alter that you have merely shifted from a human agency to a robotized mechanism. So therefore, the liability in law does not alter. And that is the reason that these challenges of algorithmic collusions are dealt with by the agencies with the existing antitrust tools, which were conceived more in the context of brick and mortar economy. So therefore, number one, the existing laws are sufficient to address these challenges. And the question whether algorithmic collusion is something which antitrust law can look at, the answer is resounding yes, because here you have only changed the medium from a human agency to a robot or the pricing bots. So therefore, as regards the legal liability is concerned, I do not believe there is any significant challenge which the authorities would face. Now, the second issue is how the algorithms can help in collusion to the enterprises. Now, I would say it can happen at broadly 3 levels, and these are very important for us to understand. The first scenario is where the algorithms are programmed in a way that they take the feedback from the transparency in the market, from the available information in the market, and thereby it facilitates coordination. So here the players are not talking to each other. Their algorithms are not talking to each other. Rather, each one is using one's own algorithm and programming is done so as to feed it with the competitor's data, which is otherwise freely available in an oligopolistic market, and therefore it is only facilitating coordination. Now, if there is a pre-existing coordination, then this type of mechanism can detect a deviation from the agreed cartel arrangement. So this is the first scenario which can happen. The second scenario is where firms are using algorithms which have been developed by third parties. So a common third party which has developed the algorithm has licensed it to different players who are operating in the market. Or it may so happen that the platform itself has delegated its pricing decision to a common intermediary. So in this scenario also, there is a situation of hub and spoke cartel. Coming to the third situation, and this is slightly considered to be tricky by some authors, that is when the algorithms autonomously speak to each other, meaning thereby they develop their own language and they talk to each other. Now this is, we are talking about machine learning and artificial intelligence. Now here, of course, there are no explicit instructions to the algorithms, but they are autonomously coordinating their behavior through their own language. So now all these three scenarios, if you ask me, I believe they are squarely captured within the competition law framework, even the existing framework, I must say, and they can be suitably addressed. The second issue, of course, which comes is of the capacities and the technical expertise to examine these softwares and these complex programming and algorithms to detect as to whether these programmings have been done at the instance of the enterprise concerned. In that event, of course, the enterprise will be squarely liable. But even otherwise, so long as the algorithm is used by the principal cannot be absolved from its principal liability. So in this view, I must, just to start the discussion, I must mention that these are the three different ways in which the collusion may take place in the algorithm-driven online world. And as regards the various competition agencies, I must say that they have treated them with the existing tools, and they have not come out with any separate dispensation to address collusion through algorithms. So existing tools have been applied and deployed by the competition authorities in addressing this type of behavior. The other issue I would say that even the European Union, and they have conducted a market study and which brought out that they are using these softwares to track. Now, I must mention that in May 2017, European Commission's e-commerce sector inquiry found that approximately 28% of respondents use software to track and subsequently adjust their own prices. The Commission noted that, among other things, increased price transparency through price monitoring software may facilitate or strengthen both tacit and explicit collusion between retailers by making the detection of deviations from the collusive agreement easier and more immediate. This in turn could reduce the incentives of retailers to deviate from the collusive price by limiting the expected gains from such deviation. So this was the outcome of the study. Now 28% is quite significant, that now they are using increasingly these softwares to track the prices, and which is then fed into the algorithm, and thereby they respond dynamically to the market. Now, whether that falls foul of the competition law, that's a certain matter, separate matter. But as regards the increasing use of technology in this is a very crucial finding. Now, where firms use the same algorithmic system to set the prices, including by using the same software or services supplied by a third party, or by delegating their pricing decision to a common intermediary third party, this can also create a hub and spoke structure and may facilitate information exchange. Now, in this regard, I would like to mention that Competition Law Review Committee also looked into the possibility of hub and spoke type of arrangement in the new age market economy. And after extensively referring to the jurisprudence and the legislations across the globe, there is the conclusion that the existing framework is good. However, they suggested certain changes in the structure of Section 3 of the Indian Competition Act, which deals with cartels, by extending the presumption of appreciable adverse effect on competition in the context of hub and spoke cartels. Because as the existing arrangement will be only able to capture the spokes within the framework of this presumption. And as regards the hub, the appreciable adverse effect on competition has to be established by virtue of the factors mentioned in section 19.3 framework. So this is quite, you have to divide the entire inquiry into two parts, and that is very unworkable. So I think the proposal of the CLRC and the consequent incorporation in the statute in the forthcoming bill would go a long way in addressing the hub and spoke cartels in the digital world, whereby the presumption would capture the hub along with the spokes, even though hub may not be at the same level with the spokes, and thereby this extended presumption would help in detecting and busting these arrangements more effectively. Now, before I conclude, I would just mention that these issues are increasingly become very common because industry-wide use of pricing algorithms increases both market transparency and the consequent risk of tacit collusion. In programming its pricing algorithms, firms likely to use historical pricing data and competitive response to calibrate their dominant strategy. As such, when the algorithms operate within the greater transparency of their digitalized environment, the computers will already be programmed to anticipate and respond to rivals' moves. With the computer's ability to police deviations and rely on prior strategies to punish deviations, prices as a result of their conscious parallelism will likely climb, not only in duopolies, but in all concentrated markets, including the oligopolies. So to sum up this point, I would say the OECD has also looked into these things, and they have also cautioned that despite the clear risk that algorithms may pose on competition, this is still an area of high complexity and uncertainty, where lack of intervention and overregulation could both pose serious costs on society, especially given the potential benefits from algorithms. Whatever actions are taken in the future, they should be subject to deep assessment and a cautious approach. Thank you, Amit.
Thank you, Dr. Singh. Thank you for the insights from a regulator's point of view. Now I'll go to Professor Rahul to give an industry as well as an academic point of view as to how the competition law should deal with different forms of algorithms, and whether, because of our limited knowledge that we have in this segment, are we trying to, or are we susceptible to over-regulate that sector, is a moot point which has been questioned many times across jurisdictions. Over to you, Professor.
Right. Thank you, Amit. So, in the context of algorithms, if we are worried about over-regulation, and I suppose consequently the worry could also be whether because of that over-regulation we are somehow, I suppose if that's the worry, see, I mean, one thing we must actually say upfront, which is insofar as, let's say, any particular conduct which falls within the framework of cartelization is concerned, we don't see, even a theoretical justification behind suggesting that I should be allowed to cartelize because I'm innovating, right? So to that extent, let's be clear that, the idea is not to suggest that, because somebody is innovating, therefore they are permitted to cartelize. And I'm assuming that everybody understands what the definition of cartel is. Like briefly, what would it mean? Like essentially, two entities come together, either maybe collude on prices or output, or maybe they allocate geographic markets, or maybe potential bids. This is what the scheme of Indian Competition Act is, right? But you see, the Act, of course, also goes a little further, right? Which it talks about if you not only collude directly, but the enactment in section 3(3)(a) also talks about indirectly, right? To that extent, of course, the moment we say that two entities are coming together, they collude, even indirectly, they would be captured within the text of the statute. So insofar as the text of the statute is concerned and insofar as CUTL is concerned, I don't see any particular problem over there. I don't even see a HLA hard type of open texture problem insofar as the enactment is concerned. So if we say we are worried about some kind of chilling effect upon innovation, what are we really concerned about? Maybe I suppose now that Thibaut is here, I suppose I can only mention it in the passing, which is possibly we are thinking about newer technologies which are up and about. Thibaut has this very interesting paper on blockchain. I of course read in the run up to the panel conference. And I think, so if the idea is that are we worried about these newer sort of technological concepts, which may possibly, I suppose people who are engaged in the ideas related to blockchain, will they feel that the definition of CUTL is so fuzzy? Maybe the edges are not sharp enough because of which there might possibly be some kind of a chilling effect. In those contexts, I suppose, and there is also the CCI discussion paper, right, where they have put in this idea of blockchain and how should Competition Commission start looking at this idea of blockchain and stuff like that. I suppose to that extent, one can assume that a right approach for the Commission would be to possibly think from a market studies perspective, think about what could be the possible pros and cons, what are the costs, what are the benefits. For instance, the theory is here as well, like, what could possibly be the impact on cryptocurrencies and other Bitcoins, or let's say, other aspects in which India is thinking of utilizing blockchain. So in terms of just, because you asked me for an academic perspective, I thought, briefly the answer is, I can't see any defense against cartelization, of course, because, the statute is clear. But that said, if we are worried about some kind of chilling effect on innovation, one possible way forward could be for the Commission to think from a market study perspective rather than, engaging in, let's say, conduct related or enforcement related activities straight away. That's all I'll suggest. But over to your next question. So back to moderator. Thank you, Amit.
Thank you, Professor Rahul. The next question is specifically, okay. Welcome, Dr. Sherpal. Can you hear us?
Hello, yes. Sorry, I was late. I was stuck.
The next question is for you, sir. What is the extent of liability which we are looking at when we talk about blockchain and algorithms, and when it comes to the human agents involved behind the blockchain framework or the algorithmic framework? When we see how blockchain works, it is a very decentralized version of a one-to-one networking which is happening. But when we see the way our Competition Act and the Antitrust laws across the globe functions, they focus on enterprises and a few entities. But are we ready to handle this decentralized version, and whether we have some liability to be imposed on the human agents behind the algorithms involved? Over to you, Dr. Shepard.
Sure. Of course, that's a question you could spend 1 or 2 PhDs on, I suppose. But to be brief, I think it's important to make a distinction between the medium, which is used for, potentially something anti-competitive, and then the practice itself. So if we have a look at the practice itself using an algorithm to collude, and then the question is who's liable, what I want to show you, and I hope you can see my screen right now, is that if you do indeed use an algorithm, and we could discuss, how to do that, but I think you end up with 2 main questions. First, how to detect, and second of all, who's liable indeed. And depending on the algorithm we discuss, and I think we have to talk about the technique, because if it's supervised or unsupervised, it's not exactly the same. But you end up with several possibilities. And the thing I wanted to show you is this. On the idea of the liability, we, of course, as lawyers, I think we can trust that lawyers will find someone to be liable, right? That's what lawyers do, and they will find someone. I'm not too worried in that respect, but of course we want the person to be liable, to be the person who's, really in control of the technology. And what I wanted to mention is that you could actually think about technological solutions to, algorithms colluding with other algorithms. And I've listed a few on the screen. But basically the idea is that you can limit the capacity. So you could say, well, that algorithm will impact the real space just here and there, or you could limit what the algorithm will do. So to be very concrete, if you use a supervised learning algorithm, what you do is that you give some data and you tell the algorithm, find the output, but I'm going to tell you exactly the output that I want you to find. So here you could think that the person, who designed the algorithm or the person who's using it might be liable. If it's unsupervised, it's a bit more tricky, because what you say is that you give some data and you basically tell the algorithm, find a way to classify the data without me telling you. So this is where, it will be more complicated. And this is where we have to talk about the tech solutions. And something else that you may want to achieve is to limit the motivation of the algorithm. And this is the idea of low is code. And of course, we could be discussing that. So I just wanted to mention that. And to answer your question, when we move to blockchain, which is one medium you can use to put algorithm on top of it, then you do have several issues that we will be discussing. But straight to your question, you may, indeed, we know that we apply competition law to firms, defined by Ronald Coase as a zone of, vertical control. And especially in a public permissionless blockchain, there is no vertical control, meaning that there is no legal entity. And so how do you apply competition law if there is no entity except for a bunch of people coming together and doing something potentially illegal? And I think in that regard, we have no choice but to recreate a legal entity to capture blockchain. Of course, the question is, how can we create that legal entity in a way that makes sense? I'd be more than happy to answer, subsequent questions, but this is all I wanted to say for now. But at the end of the day, when we talk about, algorithmic competition, I think it's very important to consider the medium on top of which the algorithm function. If it functions on top of a blockchain, it doesn't have the same characteristics. If it's a machine learning, we have to talk about the different types of machine learning. It could be an expert system, which is much easier to tackle. So we have to talk a bit about the technique. Otherwise, this is just lawyers talking to lawyers. And I'm not sure we would increase the common good that way.
Thank you, Dr. Parsheera. Now, having discussed a bit about how algorithms work, we'll now move towards the way blockchain and smart contracts work. To give a brief to our audience as to how the blockchain technology works, it's an encrypted version of what we call as hash encryption. And the way it works is for the transactions which happen between different parties directly, by not involving the intermediaries, or let's consider them as banks for an instance, these transactions are recorded and are very difficult to delete or modify, thereby creating a chain of blocks, which we call as blockchains. Now, on that note, I would go to the next question which we have for today's evening. I would request Professor Rahul and Professor Smriti to give the Indian jurisprudence as well as the international jurisprudence about how the collusion laws with respect to collusion interact with these kind of new age technologies like blockchain and smart contracts. And is the Commission at present looking at any of these from a legal point of view? Over to you, Dr.
So Timo, you should go ahead. The Indian answer is very short, frankly. So. Okay,
no problem. So yeah, you managed to give a definition of blockchain in just 30 seconds, which is never easy. So well done. Yeah. And I don't have to do it now, so this is good. So indeed, you have a chain of blocks and it's immutable, especially the more users, the more it becomes immutable, because basically if you want to change the ledger, you need to change all the versions. So that's the basic idea. And what's important is that what you record in a blockchain, in the blocks, are transactions. They could be transactions about the past. So you could say, I sent a Bitcoin, or this company transacted with this company, which is one thing. It could also be transactions about the future. And here we talk about smart contract, which is if and when certain conditions are met, I want the smart contract to be triggered automatically. And this could be helpful, I believe, for colluders. And here again, I want to show you something on my screen. Vitalik Buterin, that you may know by name, who's the creator of the world's second largest blockchain, actually said that a better definition for smart contract, or better name of calling them, would be persistent scripts. And I very much agree, because this is what it's all about, right? you put that future transaction on the blockchain, and then once it is there, you cannot get rid of it, which is good because it creates trust. You know for a fact this will be triggered, which could be bad if you forgot to include something or if you want to stop. It might be that you design the smart contract in a way to stop it, but if you forgot to include that, then there is nothing you can do. And that, I believe, can be good for certain collusions. And what I wanted to show you is the following. Everyone in the room have heard about the prisoner dilemma. So again, I don't have to explain that. Of course, the best outcome for them is to lie, right? If the police has no evidence that they've committed something illegal and they put in 2 separate cells, if they both lie and say, I haven't done anything, then they won't go to jail. So that's the best outcome. But it is a non-cooperative game. The reason why it is non-cooperative is that once they are in jails, in 2 separate cells, they cannot force the other prisoner to lie, right? So they never know for sure that the other will lie. And the same is true for collusion. All the collusions ever implemented in the history of competition law or business relationships are non-cooperative because, of course, you could say, let's agree that we will never apply for leniency. But I mean, you can even sign a contract saying that. But if one company one day wants to apply for leniency and go to the ICC or any other competition agency, you cannot go before a court and say, we had a contract in which we say we will never apply for leniency. Can you please enforce the contract? The contract is illegal by nature. And so for competition agencies, what they do, and this is really obvious if you read especially the annual report, is that they try to re-inject some uncertainty so that one prisoner or one here colluder will apply for leniency. But with smart contracts, I think it might change. Not because you may be able to go before a court and say, can you please enforce my smart contract? But because, again, it is immutable. So you know that the code will automatically be triggered. So it might be that you say, if someone deviates from the cartel, I want a smart contract to be triggered, and this is the punishment that you will have to pay. So you could think about a new way to design collusion, which in a sense is changing the nature of collusions, which isn't true if we just talk about algorithm. But if we talk about algorithm on top of blockchain, and especially smart contract on top of blockchain, they make collusion cooperative because you can force the other colluder to behave in a certain way using smart contracts. And that, I believe, is something which is a new challenge for the field of antitrust. And again, it shows that the medium is very important. So every time we talk about algorithm or related technologies, we should mention which medium is used for that algorithm to function. So this is a big challenge for competition agencies. Of course, there are things they can do. More than happy to discuss that. But I expect that we're going to see more collusion, or at least they're going to be more effective. And discussing with some people in the space of the blockchain ecosystem, I think they are already implementing collusions using smart contracts. So it's a matter of expertise for competition agencies to detect that. And once again, thank you very much for organizing such a great event, because to spread the expertise is exactly what we need to do right now, so that we can do something about it in the future.
Tipo, a follow-up question before we move to Professor Rahul for his comments.
Sure.
So when we look at the liability as well as the amount of data which is involved in between the blockchains, when it comes to a distinguishing between public blockchains and private blockchains, we see that OECD and many other bodies have come up with a distinguishing liability regime for these 2 blockchain systems. What's your opinion on that?
Sure. I mean, to be very blunt, you could say that on a public permissionless blockchain, there is no pilot in the cockpit. So there are relations of powers, of course, always. I mean, that's human nature. But no one can actually impose a decision on others. And that is, very much different from what we have in a firm, where the CEO or the shareholders may actually impose order. And so for that reason, you may think that an abuse of dominant position doesn't mean anything if no one can actually abuse, because no one has the power to abuse. It's not that easy, but that's the idea. For a private blockchain, it's actually the opposite. You do have a clear pilot in the cockpit. You could have a few pilots. It will be called a consortium blockchain, and those pilots can, of course, take the plane in a different direction, and this direction might be anti-competitive, but they do have the power to do that. So it's more obvious when it comes to private blockchain who might be liable, because whether they choose the illegal direction for the plane, or they could have, stopped some users to go in this direction. When again, for a public permissionless blockchain is not that clear, and this is why we need again to discuss which legal fiction is behind it, because otherwise all you end up to do is just punishing certain players in the public blockchain for individual practices, but you will never be able to capture the strategy coming out of the blockchain itself. And we see that blockchain compete and they engage in practices. So if you want to capture those practices, above the individual level, you need again to discuss which legal fiction do we need behind it.
Thank you, Sir, for the insights which you gave on such a complex issue. Now I'll go to Professor Rahul for his comments on the Indian jurisprudence with respect to blockchain and smart contracts and the liability on them.
Okay, I'm just taking off from where Thibaut has left off, right? So in terms of, let's say, looking at the idea of collusion, I suppose it would be very simply that Indian Competition Act is not like some 10 commandments which just says don't collude and stuff like that, right? It's more like any other law where you have a set of ingredients, you have to parse the ingredients of the statute. And since Thibaut has cited Posner, I'm tempted to utilize law and economics, which is essentially suggesting that, well, so long as each of these ingredients are satisfied, and I suppose if one could go further, is that if the commission is able to prove that these ingredients were satisfied, there would be an infringement which will come about. But I suppose we are very far off from that, right? Considering that if one has to do a reverse logic of discussion paper, I would assume that the commission is also thinking as to what are those areas in which one can think of application of competition law when it comes to blockchain. And because Thibaut cited this idea of prisoner's dilemma, I'm tempted to mention one more thing, which is, although law and economics literature is full of application of prisoner's dilemma, one enterprising economist, in fact, decided to test prisoner's dilemma in China, not India, China. Okay, and with very interesting insight. And I'm very, tempted to mention what was that insight. This is, I think, Malloy goes to China, tests prisoner's dilemma, and finds that contrary to law and economics prediction, in fact, none of them confesses to the police, because it turns out that in Chinese society, nobody trusts the police. And therefore, the idea that law and economics mentions that it's not necessarily true. I would suggest that in all societies, it will work out empirically speaking. Of course, you see, I'm not suggesting we have enough evidence right now to suggest what might happen in the Indian context with respect to leniency regime that India has, particularly if blockchain is being applied. But if theoretical assumptions have to be formulated, if certain predictions have to be made just based on law and economics sort of a theory, insofar as the evidence from a developing country like China comes about, looks like prisoner's dilemma might not work in a Chinese context. I don't know really whether it will work in Indian context or not, because I don't have evidence of any particular economist conducting that survey here. So let me stop over there and over to you, Amit.
Yeah. So just because Professor Rahul mentioned about law and economics, I'm reminded of a concept of law and programming, which was discussed by Thibaut in a OECD conference. Could you throw some light on that?
Sorry, can you repeat?
Yeah. So because Professor Rahul talked about law and economics, I'm reminded of the concept of law and programming as a new stream, which you have advocated before OECD in your discussion paper. So could you throw some light on that, so that our audience knows what is the interaction between law and programming?
Sure. It's funny because now I do remember that I said that indeed, and that's something that I wanted to discuss. So I thought I would keep that for the end of today. But since you are asking me the question, I mean, as I said already, I'm not saying that law and econ is not valuable. I mean, of course it is, right? If you want to understand, certain practices and why companies are doing it, potentially we rely a bit too much on neoclassical economic theory, and we think that everyone's rational when it's not so true or always the case. But as I said already, you need to understand what's the programming and what's behind the technology. The more it goes, the more we see agencies being concerned with that companies may implement anti-competitive practices within the code and the programming of their software, and applications, when, even the Google decision before the European Commission are discussing contracts. And so I think that's good, because otherwise it creates a major legal loophole where you basically tell company, if you want to do something illegal, do it in the code, because we never have a look at it and don't do it in the contracts. And so what I wanted to mention is that, and I don't want to give the impression that, all lawyers should learn how to code softwares and to be able to design their own blockchain from scratch. But I very much think that if we do not understand the basic of it, then we end up discussing, either we end up discussing solutions that cannot be implemented, which is often the case in the blockchain sphere, or we end up discussing problems which are not really problems, or we end up not seeing the right problems. And so for that, what I've tried to do is to list all of the resources that lawyers, so not computer scientists, but lawyers could use to learn computer science. And all of them are free, open access. So I've put the link here. You could, scan the QR code. I'm more than happy to send you the link. And I've done quite a few. And again, I think if we do not do that and understand a bit of what's happening behind, the code, we're going to be lost eventually. So this is a call for action. And again, if you want to get started, there are some resources that you could be using, very fun. You will get a certificate at the end of it, so you could use that. So please be in touch if you are interested in that.
Sure thing. Thank you. Because I was extremely interested in the way you portrayed the concept of law and programming in your paper. So now I'll go from a lawyer's and academician's point of view to a policy point of view. Now my next question is directed to Smriti. If we look at a policy from a policy point of view, we see that technology is rapidly changing, and the way antitrust laws are evolving, are they able to keep up with the pace in which the laws or the technologies are evolving? So is the technology and the law able to side by side supplement each other, or is the technology evolving too fast? As to what Albert Einstein says, I don't think of future because future comes too soon. So is the law able to come able to somehow regulate the way technology is growing? Because every day a new form of technology, be it blockchain, be it smart contracts, be it any other, be it the AI regime. So is the law equipped that well, and will the law be able to cope up? Over to you, Smriti.
Thanks, Amit. And let me start by thanking LTech and ACLA for having us all here in this discussion. Always a pleasure to be at NLS, even if just virtually. I'm going to start by just foregrounding, and in a sense, I'm repeating what previous speakers have said, but I think it's important to link that to the question of policy that you've posed to me, is this idea that, the fact that algorithm, although we use it loosely, is a very broad term and has a lot of subsets. Not all algorithms are equally complicated. Not all of them have the same kind of outcomes, the same kind of technology going into it. And therefore, when we think about policy interventions, or when a competition authority is doing an investigation, it's really critical to understand, which kind of algorithm is at play here, what kind of machine learning, and within machine learning, as we've just heard, there are multiple types. So is it, are neural networks being deployed? Because that's possibly in the known kind of set of technology, one area where, you could be what people usually refer to as the black box cases, where you really don't know why certain outcomes are being generated, and that explainability is lacking. But that's not really the case in most traditional algorithms, and even in supervised machine learning, you'll not encounter those issues. So when you think about questions of liability and who is liable, it's important to understand, which technology is being deployed, and therefore then investigate, conduct based on that. So another distinction is that, it's linked to this point that all of the AI that we know today is really all what is called weak AI, right? So we don't see strong AI, and some people say we don't even know if we can ever get to strong AI in the sense that has true intelligence and conscience and intentionality and all of that. So we are nowhere near that. So in that sense, also when you come back to questions of liability, it's very much about the designers and the deployers of these systems, the ones who decide which problems are the ones worth solving and what outcomes they want to get to, even though they don't code the exact process in some of the cases. They are the ones who clearly remain liable. So liability, I guess, is, even from a policy perspective, not the bigger issue. The issue is, can you prove the conduct that you are trying to set out to prove? And I think that's one of the major issues which comes up in these context around collusion when you talk about that. So actually, to foreground that, most of the discussion around algorithms happens to be around collusion. But if you think about collusion, I mean usually around horizontal collusion, right, whether it's bid rigging or setting of prices. But actually, if you think of all of the other kind of cases that competition authorities are looking at in the technical sphere, including what the CCI has looked at, a lot of algorithmic issues are coming up even in abuse of dominance cases, right? So the search bias questions against Google, all of this is about, how does search work? How is certain things ranked at what scale? Is it favoring its own services? It is about how the algorithm functions. Similarly, when you think about vertical arrangements, I know the CCI has the case, about the Flipkart and the Amazon case about marketplaces and whether there is a situation where, certain sellers are being favored, whether there are arrangements there, whether there's preferential listing, whether there's deep discounting for certain players. It is eventually all being implemented through algorithms. So it is really essential to then go back to the previous question of which kind of algorithm is being applied in each of these cases, and then, then deconstruct it from there about, what is the right intervention. But to go into, some of the specifics of what kind of barriers we see, or, what needs more interpretation, let me not call it barriers in the competition law sphere. The first is, of course, the concept of an agreement, right? If you're looking at anti-competitive agreements, you need to establish that there is an agreement in place. And that's the case with most collusion cases so far. Forget from an algorithm point of view, even without that, a lot of cases have been dismissed just because you may have an anticipation that certain conduct is happening. You have a hint of that, but you're not able to show that there was a meeting of mind, that people got together, whether physically or virtually, and there was that exchange of ideas, that acting in concert concept, which is necessary for showing, that there is an agreement. And I guess that becomes even more so enhanced in the case when you're talking about algorithm, because proving conduct becomes that much more harder, especially when you don't have full explainability. The other, Dr. Singh spoke about this right at the beginning, this idea of the hub and spoke model. And actually the airlines case, even though it doesn't deploy the term of hub and spoke, is essentially doing that kind of an application, because it's asking that if there is one software vendor which is providing software services to determine prices to a lot of airlines, is there a possibility of collusion between those airlines as a result of that happening? And that's essentially, the idea of hub and spoke, whether horizontal arrangements are being achieved through a series of vertical arrangements. And interestingly, in that case, they went in for the fact that there is a human in the loop, that the algorithm is only throwing up certain suggestions, but ultimately there is someone who is a revenue collecting officer at the end of the airline companies, and that person is making the final determination. But in my view, where the decision stops short, and actually this may be something which has happened at the back end but is not reflected in the text of the decision, is that although we know from the DG's report and the decision given by the CCI that there is some application of a human mind, that extent of application is not clear. So we don't know out of the cases in which the software was used, what percentage of the cases were cases where people applied their mind and changed the suggested price, and by what extent did they change it. And so these numerical values could become really important in really determining whether there were people acting in concert. And as I said, probably this has happened, but I couldn't see it being reflected in the text. So I'll stop there. Actually, one last point before I stop there is this idea of the competition review process happening, right? And one of the ideas we've seen there is the fact that you need ideas of a settlement or a commitment, which you see in so many other jurisdictions, also being translated in the Indian competition law. And why that becomes really important in these kind of cases is because, for all the reasons we've been discussing, it's hard to prove collusion. It's hard to prove collusion where algorithms are involved. And if, investigation authorities invest their time, it's no guarantee that you will really reach an outcome. So in that situation, there is a signaling effect which can be achieved by starting some of these investigations, but, closing them without trying to determine liability, and in the process achieving the result of some some of this conduct changing. So I think from an algorithmic accountability point of view, it may be good if we went down that path. Thanks.
Thank you, Smriti, for the insights on policy point of view. Again, I'll come back to Dr. Thibu. Thibu, from an EU point of view, when we see the regulation of algorithms and AI in terms of how the automation works across industries, we have seen that a new regulatory regime is coming up. In that context, should other jurisdictions also advocate a similar regulatory regime when it comes to the use of blockchain or the use of algorithms to tackle the antitrust issues which have arisen across jurisdictions? When we see different cases being filed in India, in US, in many countries with respect to how these companies are using the algorithms or how they are using the AI framework to subvert the competition or to exploit the market.
Sure. Again, I'm going to do my best to answer a fascinating but complex question. So in Europe, you may have heard about the DMA, the Digital Markets Act. It will never say, it goes after this kind of algorithm in a very specific manner, but certain practices are prohibited. So, they tackle companies using algorithm for certain purposes, but it is directed at not the technology itself, but at certain use cases. And the same is true for the AI Act that was put out. That's just a draft, of course, same for the DMA a month or two ago. And the European Commission here is very much concerned with the high-risk use of AI. It will have an impact on the competition and the dynamism of markets, whether it's good or bad, but it's not concerned, again, with the tech itself. It's actually a bit surprising. The European Commission is defining AI as a software. I'm not sure if that's only a software, but they are not concerned with the tech itself. I understand the reason, but also it might be curious because they end up saying that if you use AI in a certain field, then it will be considered high risk, and therefore you need to disclose and ask the permission in some cases. But let me say that you use just expert system, which is just a bunch of rules. If then that, I'm not sure if the control risk, even though you might be in a space which is dangerous, is as high as it is if you are using, a deep learning system in a field in which is less dangerous on paper, but since you will have no control, I'm not sure if at the end of the day, disregarding the difference between the tech is such a good idea. And here again, I wanted to show you this, and we all agree on the panel, so this is great, right? That we do need to discuss the tech, and it's actually very complex. This is not for you to analyze, just to show you that when we talk about AI, it could be all of that. And so it could be very complex, but at the end of the day, when we talk about AI and competition law, here what I want to show you is the following. I think it's fair to say that you could have three scenarios. Scenario number one, you do have two human beings, and they agree, they meet in a cafe, and they would say, yes, let's agree to implement a cartel. And of course, they use a computer to exchange emails. You could say algorithms are involved, but it's very basic. Scenario number two, they are in the known, the human being. So they know that computers will do something, but the humans are behind the computers and giving orders to those computers. And scenario number three is the scenario in which the computers themselves, whatever it means, decides, to collude. And so if we look at, of course, scenario number one, this is now, all infringement of competition law. Everyone is using a computer. Scenario number two, you do have a few cases. So you asked me about Europe. I've put the references to two cases before the General Court, the Court of Justice in Europe. What you do, long story short, is that what you see is that companies are using the same software, so to be able to coordinate their prices. So this is, scenario number two. And if you look at the evidence for scenario number three, in which the algorithm will collude with other algorithm, this is what you get. And this is not a mistake that there is nothing on the screen, because we don't have any case discussing this. I'm not saying it does not happen, because indeed detection is really hard. Of course, we have lots of studies and reports. This is the number of papers, academic papers, written on the subject of algorithmic collusion meant as the third scenario. So maybe it's declining, but you could see, you know, it's quite a few papers every year being published, and yet we don't have any case. And so it doesn't mean that we don't want to care about, you know, and to try to tackle the issue. But as an agency, you do have to direct your resources where, you know, you could have the better impact for consumers. I'm not sure if spending so much money on writing reports and, you know, doing all the work that they do regarding scenario number 3 is what we need to do right now. So I just wanted to mention that. It might be that there are some cases in India dealing with scenario number 3. I don't know if you are aware of any, but in Europe, I haven't found any. And same in the US, by the way. So something to keep in mind, I guess.
Thank you, sir. The next big question which we have to look at is, I am tempted to ask it to Professor Rahul. So the way the current technological advancements are happening, are we looking at striking a fair balance between innovation and competition law goals? Is it possible to, you know, over-regulate or under-regulate the segment? Are the current laws enough to regulate the tech changes which are happening? And one more question, because Rahul sir happens to be an expert in evidence law as well. So how do we prove the collusion when it comes to the blockchain and such kind of technological frameworks? Because gathering evidence is a difficult task which many authorities have flagged when it comes to the new age technologies. What do you, Professor Rahul?
Let me quickly piggyback on what Smriti mentioned actually about the airline cartel, where the CCI found a human element and somehow that was sufficient to close the case. Maybe therein lies the answer in my view, which is it looks like proving it is harder. Maybe the commission is also thinking how exactly to prove it. So on the evidence bit, I'll quickly say that. On the first bit, which you mentioned, this idea of regulation, I think in several other forms, the question cropped up yesterday as well, whether technology is something which might be an exception to the norm of competition law. And we have seen that, you know, these questions keep recurring. Of course, you see in all contexts, it's possible to either over-regulate or to under-regulate. That's why I suppose we have, maybe, you know, if I can borrow from blockchain, like therefore we as a society, I suppose we have repose some kind of trust in a competition agency, right? Of course, blockchain is seen as some kind of a trustless model. But I would think that you see CCI is the agency which is supposed to find a way which would be somewhere in between over and under regulation. But let me stop there because I think we haven't really also heard from the team. So, you know, I'll leave it to you to ask the question.
Okay. So the next question is directed to Mr. Amit. Mr. Amit, we would like to know about how the blockchain framework or the blockchain technologies help modifying the antitrust laws across jurisdictions, including India. If we consider the recent paper, which was a discussion paper, which was circulated by the Antitrust Commission of India with respect to how blockchain functions and how India is looking at it. So what is your opinion on what kind of modifications are required, or is the current regime enough to cover the changes which blockchain brings in?
So I'm glad you mentioned the CCI discussion paper. It frankly comes as a breath of fresh air, frankly, because it presents blockchain both as a friend and as a foe. Because essentially, blockchain is per se neither pro-competitive nor anti-competitive. Though, of course, it will unquestionably interact with competition law and present new challenges to it. So blockchain technology right now is evolving, and most blockchain applications are in a pilot or proof of concept stage. Thus, there is very little precedent or empirical information on the conduct of such blockchain applications, especially from a competition law perspective. In attempting to sort of analyze the impact of blockchain on competition law, perhaps there's a need to step back and evaluate how both competition law and blockchain exist and endure because of a sense of belief or trust, as Professor Rahul said, that their utility lies in freeing participants from concentrations of power, essentially. The entire reason why blockchain as a technology gained traction is because the underlying values inherent in the creation of blockchain are those of decentralization, essentially. That is of taking control away from centralized institutions and instead reposing control in a community of participants, wherein all the participants will have the ability to sort of make their own decisions without being subject to any centralized control exercised by a single dominant participant. In similar vein, competition law seeks to free markets from anti-competitive practices. To cite Dr. Chappelle, he says that antitrust law ensures that market players' decision-making remains free from any economic coercion. In other words, while the architecture of blockchain ensures decentralization and prevents concentration of power within its architecture, competition law punishes anti-competitive behavior like collusion and abuse of dominance in the market. In essence, ultimately, what both seek to promote is a decentralization of economic opportunities, just in different ways. So there is potential, definitely, for blockchain to actually supplement and work with competition law in their quest against centralization and concentration of control. Proactively engaging blockchain stakeholders, miners, developers, users at this stage when the technology is still developing, and making these stakeholders aware about the likely concerns of competition law that may arise and how competition authorities may deal with them could certainly help in this regard. I guess what's needed is strong advocacy and perhaps regulatory sandboxes so that competition law requirements can be coded and integrated into blockchain applications, which would benefit both blockchain stakeholders and promote the level of competition. That's about it.
Thank you, Tali. Thank you for your insights. Now I'll go to Dr. Singh, Dr. K.D. Singh, for a regulator's point of view. Can we see that? Can we imagine in future that we'll have a friendly relationship between the algorithms and new age technologies and the way competition law works? If we say yes, in that case, how are we looking at the modifications which are required in the competition law when it comes to the definition of agreement or the definition of tacit collusion? What kind of changes are we looking at for a friendly relationship between innovation in terms of new age technologies and fair market in terms of competition law? Over to you, Dr. Singh.
Now, as I mentioned in my opening remarks, that competition law as it stands today is futuristic in its ambit. India had an advantage of being a late mover in antitrust regulation. So our law is drafted on the best global templates, and it has stood the time and it has been applied, though it itself, when it was enacted, we were more under the brick and mortar economy than click and order economy. So even at the time when this law was enacted, this law did not envisage the digital evolution which took place immediately thereafter. But the law as it is framed is very overarching, and therefore, as I mentioned in the opening remarks, and as also the Competition Law Review Committee, which had a dedicated working group on new age markets. So they have examined the law threadbare, and CLRC was representative of industry, law firms, academia, regulators, government, everybody. So this was a common thread that law need no change to address these changes. In fact, making such tinkering will only muddy the waters and confuse the stakeholders. Now, today blockchain, tomorrow there may be a new technology. So law has to be technology agnostic. It cannot be framed taking into consideration a particular technology in mind, because the technologies are evolving very fast. Tomorrow something new may happen and we might not have heard about it. So every time going to the drawing board to change the statute is not a feasible option, neither for the governments nor for the regulators. It will create a huge uncertainty and burden on the stakeholders as well. Now, in its application, as you mentioned, that whether we will be friendly to the algorithms, I must say the Commission in its enforcement applies the discipline and mandate of law in a very agnostic manner without being any partisan or being having any animosity to any particular technology. So I don't think that is the case. So if the participant deviates from the parameters or perimeter of the law, then certainly CCI will red flag it. But beyond that, the law is or has to be technological agnostic, which it is. And I am happy to say that today, as the Karnataka High Court has rejected a challenge to the investigations ordered by the Commission against certain online platforms, and before that, even Delhi High Court, in the case of social media giants, they have also upheld the CCI's order directing investigations. So these are early trends, and these clearly indicate that law is sufficient and robust to address the new age challenges, and the higher judiciary has reposed full faith in the framework of the law and its application and enforcement by the competition agency in dealing with the technological dominant undertakings.
Thank you, Dr. Singh, for the valuable insights. And now, Gerard, it's high time we go to the questions from the audience. We have already Thibaut has answered almost 80% of the questions, so we are left with some other questions. Now, this question is directed to Dr. K.D. Singh. The question is, in its study on blockchain, CCI has recognized that this technology can raise concerns about collective dominance, which India does not recognize. What is your take on this?
Now, I must say that the issue of joint dominance or collective dominance was deliberated and discussed at length in the Competition Law Review Committee meetings. And after a detailed deliberation and considering the global experience, it was considered expedient that at present there is no occasion to introduce this new concept in the statute book. Because what the law presently provides is the group dominance. It does not provide for a collective or joint dominance. So group dominance is in the context of the entities which are structurally related to each other. Now, when we are talking about the collective or joint dominance, we are essentially talking about the unrelated entities. So if they are jointly or collectively doing something, I think our framework of Section 3 dealing with anti-competitive agreements is robust enough to deal with this situation. Because if we bring this concept and randomly pick 2 or 3 enterprises operating in the market to declare it to be a dominant undertaking, I think that will create a lot of uncertainty. And I do not find any solid jurisprudence and application of this concept. And certainly CCI has never felt handicapped due to lack of joint dominance on the statute book. So I think the CLRC recommendations as they stand, they recommend against its introduction. And to my mind also, that is only fair, and the existing framework can suitably address these issues.
Thank you, Dr. Singh. With these questions, I think, Harshit, have we answered all the questions from the participants?
Yes, I think all questions are answered. Mr. Thibaut has really been helpful, and he was question side by side. So thank you so much.
All right. In that case, we will leave the stage for Professor Rahul to conclude before we give the stage to Harshit.
Maybe we should allow some questions from the panelists to each other.
Yeah.
If somebody would like to go ahead and ask.
Would like to ask anything.
Okay, if nobody is asking, I'll ask Thibaut. Thibaut, you are at the receiving end today. So from your paper on this blockchain and antitrust, I was wondering, when you talk about these token effects, right? Because you say that you see when we are looking at this idea of network effects in terms of blockchain, possibly a better idea is to look at token effects. To prove that I have read your paper, I can quickly put it up on the screen as well, because after all, in God we trust. Everybody else needs to bring in data, right? So here, this is your paper. You are looking at network effect versus token effect, and you show how in blockchain there is a slightly different kind of a jump, right? So two questions from this paper I wanted to ask you. One is, are there any particular theoretical reasons because of which token effect curve behaves differently from network effect? That's one, and that will sound like one academician questioning the other. And therefore, I'll also ask you maybe a non-academic sort of practical legal question, which is this: how is token effect different from discounting, which anyway goes on? Where the loss leader strategy, which is adopted by the e-commerce companies all over, I suppose in India particularly, when they discount their prices, they sell products at very cheap rates. Those are the kinds of examples you take as well from Ethereum and all. See, I'm not from the blockchain field, so of course, pardon my pronunciation or if I get the name of the company wrong, but I suppose I have been able to convey the ideas effectively. So over to you, Thibaut.
Sure. So to answer, I'll start with the second question. And so for everyone maybe in the room, what I was arguing in the paper is that, of course, what we see with the network effect is that it takes time, right? And there is a tipping point. But before the tipping point is actually reached, it takes time. And so if there are just 100 users on the social media, you don't want to use it. And if there are 200 users, you still don't want to use it. So for that reason, we think that companies will actually, maintain the dominant position for a long time. And what you see in the blockchain sphere is actually something different. You see that users are joining super rapidly, and some are being calling that the serial monopoly, because what you see is that indeed, I mean, we all heard about all that, right? It's a new cryptocurrency, everyone is using it, and in 2 weeks it disappears. And so to answer the second question, I think it is different from those strategies in which indeed you may give away, some products, because if companies are doing that, it is costly for them. And of course, the long-term strategy is that they will eliminate their competitors, and after that, they will, recoup the losses that way. But if you discuss with the blockchain people, and I had the chance to discuss with quite a few Ethereum people, but the same is true for all of the blockchain, they will tell you, well, what we did is actually free, because what we did is that we issued a token, and it costs literally nothing, just to buy a computer, and you can then design your own token and put it out there on the market. So the costs for you as the developer or the company, if there is a company behind it, is literally zero. And yet you may use that to create an incentive for people to join the blockchain. And if it's a failure, at least because the costs were zero, you may want to start tomorrow again. So there is a difference in that sense. But where I think lawyers have a role to play is that if you do say that a token is a security, and here we enter the space of financial law a little bit, it goes with lots of regulations. I'm not saying that it is not, or that it should never be, but we need to be careful and think about financial law with competition law, because potentially if you indeed say every token is a security and you need to fill the form and ask for the permission before you acquire them, you may kill the token effect a little bit. So maybe we want that, but we need to be aware of that, because the token effect might be the reason why we see blockchain competing, with the big tech companies already in some space in just a few weeks, which is not something that you will see outside blockchain. So I hope I answer your question. I have more to come on that in a few weeks as well. But yeah, I hope I answer.
Thank you.
Any other panelists would like to ask any question to any other panelists?
Oh, I just want to respond to some comments on the airlines cartel.
Yes.
Now, one thing we have to look at this sector airlines itself, whether it is really prone to cartelization or the looking at the health of the players in the market, because this particular decision was in the context of agitation given by a community asking for reservation. So they blocked highway between Delhi and Chandigarh. And during that time, when the highway was blocked, the people were started using airlines to travel between Delhi and Chandigarh or Delhi and Amritsar. So this was, demand supply mismatch scenario. Now, to begin with, this case had its origin in this background. Nonetheless, Commission and the Director General did a thorough investigation, and I believe the judgment perhaps was not elaborate in its findings, was that primarily because it was heading for closure. So maybe in that situation, it may not be very viable to reveal so many pricing algorithms and other commercially sensitive decisions or matters in the order. But as it can be seen that all airlines were using different softwares and they were manually feeding the instructions and they were feeding their historical data. So therefore, the judgment brings this out without compromising the commercially sensitive information being brought in the public domain. But fundamentally, it addressed, and this is an overwhelming finding, that there was human feeding, human interventions, and no common algorithms or algorithms developed by a common developers were used. So I guess we have to appreciate the decision in that context. Thank you.
Thank you, Dr. Singh. All right, we have. All right.
One more question, I suppose. Yes, since we have some time, I think I can probably ask a couple of more questions. So another question, maybe to Padhy, to maybe think about and maybe share with us. Are there Indian examples where blockchain technology is already being utilized, and should, as a society, should we be more worried about it, or maybe worried is not really a right phrase? Should we be collectively thinking about it relatively more?
Yes, in fact, I just found out that the government e-marketplace was using blockchain technology to sort of make information more accessible to small and medium enterprises, which could certainly, change transaction costs for them. And there are a number of projects. The Coffee Board is also working on one, I believe, with the growers of coffee and whatnot, and it really offers. I mean, it's a really good initiative, I believe, to sort of bring information in where there is very limited information. It really helps those who are sort of on the lower rungs of the sort of information chain.
Sure. Thank you. If I may, I also wanted to ask a question to Smriti, which is, so now you have worked quite a bit on the technological aspects, particularly from Indian perspective. So one question which cropped about yesterday was this so-called tech exceptionalism, which is a lot of people feel that, technology is so rapidly changing that competition law may not be able to sort of keep pace with it. And since you are somebody who has worked in the field, would you like to maybe share some of the insights that you have earlier worked upon? You're on mute, Smriti.
Yeah, sorry.
Thank
Yeah,
you.
sure. So, I think just reiterating something we've written about in the past in one of our papers, I mean, the claim that we make is that given that competition law is a principle-based law, and we've even discussed that in that discussion here, it does actually allow more than enough scope for interpretation. So it's about the CCI or any competition authority, choosing to apply due process using the existing provisions in an evidence-based manner. But in terms of provisions, like, I'll give you an example of something like, unfair terms, right? The provision is so broad that it is completely discretionary on the authority to decide what might be unfair in a particular situation. So something like the example we started the session with, where, Uber might be charging different prices to different people. Maybe I'm a woman traveling at night and I'll be charged more because, I attach a premium to my safety. Is that something which is unfair? And, one may question whether this is a job of a competition authority to go into questions of equity. But if they choose to do so, then, the term is broad enough to call this unfair and then take action on it. So in that sense, yeah, there are problems about, what everyone's been quoting Posner, what Posner has called like new economy real time versus competition regulatory time, and that there could be a mismatch in that. So that could become a problem. But assuming you have mechanisms like settlement, you have mechanisms, which allow for some of these things to happen faster and with more evidence being utilized. And actually, that's a point I wanted to make earlier about the friendliness between algorithms and regulators. That's actually something which can be achieved by your regulators themselves relying more and more on technology in their assessment and analysis. So, if you're doing a case against Google or you're doing a case against the marketplaces, given that this is all data which is out there in the public domain, you could have systems which are constantly pinging over a course of 2 years to see how the search page changes for a particular term. Instead of, you of course can ask the company for that information, but you can dynamically be collecting this information yourself. And similarly, how the price of a certain products change over a period of time, you can, either through APIs or just by web scraping, you can collect this data and then use analysis on that. And that can really, it's a use of technology to strengthen the existing analysis which takes place.
Thank you. Since we still have time, maybe more. Sorry, somebody is asking.
No,
go ahead.
If I may say something on that, because I also wanted to discuss that, because I think it's central. Because of course, as lawyers, we are trained to see the problems. Why discussing what's going, as it should? But technology could help regulators and companies, also the competition agencies. So if I may take just 2 minutes, because this is exactly the purpose of a project that we introduced at Stanford University called Competition Antitrust, with now 55 competition agencies. So you could see there is an appetite for those agencies to understand how the technology could actually help them. And to be very specific, so the question is, of course, if you want to improve competition law or antitrust with computer science, where do you start? What do you do? And I just wanted to give you very briefly 3 examples, but one was just mentioned. So this is great. And again, we are on the same page. So I'm very pleased by that. But indeed, you could use, market screening tools, APIs, web scraping, natural language processing to try to detect more anti-competitive practices. Because for now, and I don't have the numbers for India, but for the US and Europe, we know that we detect very few of the infringement of competition law. So unfortunately, if you infringe competition law, you'll be fine most of the time. And I think we can probably do something a bit better in the field. So we could use those technology for this. Something that we know that all competition agencies could do all over the world is to start with their own case law. And actually within the project, we published a paper. They train an algorithm, both supervised and unsupervised, using the FTC decisions. And they ended up finding that when companies engage in one type of practice in the pharma markets, they also engage in another type of practice, which wasn't seen from a human eye perspective. So all agencies could start there. This is one example. The second example is the example of merger control. Why are we not studying the tech being acquired when it concerns a technological sector? Why are we just looking at the turnovers and the market shares? So in another paper, 3 researchers from the MIT actually explain how technology could help predicting whether a technology could actually disrupt existing players or not. So this relates to killer acquisitions. So this is the second example. And the third example that I wanted to show you is the one of agent-based modeling, where what you do is that you try to model what will happen in the future if you impose certain remedies, if you take certain legislation. And so this is how it looks like. So, you set up a set of rules. So you might hear the rule is that if 10 agents are coming together, they should move to the right. But if we transpose that to the field of competition law, you could have something like, if the prices of a product go up by a value of 10 points, then I want certain competitors to leave the market. And then what you do is that you run the simulation and you see what's the effect of a certain remedy or policy. And of course, you could use machine learning and AI to improve, the model. This is a good example in which they play a game of hide and seek. And what you see is that if you play the game several times, the blue agent will learn how to hide from the red agents. And again, it seems that agent-based modeling is now ready for competition agencies to use to simulate the effect of remedies instead of doing what the European Commission unfortunately did in the Google case, which is, it's too complex, so let us ask Google to design the remedies, which took for several years. So technology, could also be helpful, and I wanted to leave on that positive note because, although there are problems, there are also opportunities in the space.
So I like your slide deck, Thibaut. If you can maybe go back to your collusion slide deck, I had a question over there, which you showed much earlier, actually, maybe an hour ago on collusion.
A slide that I showed?
Yeah, on collusion a while ago.
Was it the one with the 3 scenarios?
The one with the protagonist from Her.
From, yeah, but he's all over the place. So let me see. Is that this one you're talking about?
Yeah, this is the one. I was just wondering what collusion this guy entered into, actually, that tempted you to put him on the slide deck.
So sorry, what is the... Can you
what
repeat
is the collusion in Her that came to your mind? Why is he there on the slide deck?
Yeah, well, why the reason why I chose that movie, if you haven't seen the movie, this is a good movie.
We have. I think a lot of us probably have. So go ahead.
So the reason why I choose that movie to, give a certain feeling to the presentation is that when the movie was released in 2013, this was crazy. The idea that you could fall in love with a computer was crazy. And I think the same was true in the field of competition law, right? The idea that companies could use technology to collude was a crazy idea, although it was just 7 years ago. And now it's almost normal, especially in the COVID time, right? To have a kind of a weird relationship, if not a love relationship, but a friendly relationship with your smartphone is something totally normal. And I expect that it will be totally normal that we discuss, machine learning in a very specific manner in the field of competition law in just, we are doing it already today. So this is the reason why I choose that movie, but there is no collusion in that movie, or at least not that I've identified.
Sure.
I hope,
Thank you.
Yeah, I answer your question.
Thank you. With that, I think, I have run out of my questions. We have also run out of time. Of course, if anybody else wants to ask any question, please go ahead. Okay, Harshit, Kabir, do you want to propose a vote of thanks formally?
Yes, sir. Thank you so much. So now that we've arrived at the end of the brilliant discussion for today, as they say, all good things must come to an end. So I would like to take this moment to briefly extend gratitude to everyone behind the successful completion of today's session. On behalf of myself and LTech, ACLA, and NLSIU, I thank Professor Rahul Singh for his sharp insights, which were key in giving velocity to the discussion. I also thank the other extremely learned panelists, Professor Thibaut Schepel, Mr. K.D. Singh, Ms. Smriti Parsheera, and Ms. Tathir Fatima for their diverse and enriching perspectives in the discussion. I thank Professor Amit Kumar Padhy for skillfully moderating and navigating the discussion. Finally, I would like to thank our valued attendees who enriched and contributed to the discussion with their ingenious queries. I trust that it was an extremely worthwhile experience for all attending the event. Kindly allow me to remind you to kindly fill in the feedback forms, which are accessible through the link in the chat, so that we may incorporate your suggestions toward future events, and also send across your certificates as a token of our appreciation and a memento of the event. This was Kabir Jay, Joint Convener of LTech. Once again, we thank you all and look forward to seeing you in our upcoming sessions over the next 2 days. Good evening and see you tomorrow.
Thank you very much. Dot on time. Thank you.
Thank you,
Thank you,
Kabir.
everyone. Bye.
Thank you, LTech.
Thank you all.
Thank you, Rahul, sir, for organizing.
Thank you.